The knock came at 7:15 on a Thursday morning in October. 2 sharp raps, followed by a third, that was harder than the first 2, the kind of knock that doesn't leave room for not answering. I was at the kitchen window with my back to the door, watching the frost burn off the back field in the early light the way I did most mornings, when I had nowhere to be, which was most mornings. I put down my mug and went to answer it. The constable on the porch was younger than my boots. He wore the olive-green uniform of the Ontario Provincial Police and held a manila envelope against his chest with both hands, the way you hold something you'd rather not be carrying. He wouldn't quite meet my eyes. "Mr. Dunmore," he said. "I'm Constable Merritt, OPP. I apologize for the hour. I have a court document I need to serve." I took the envelope from him. The words at the top of the first page came into focus before I was ready for them. Application for writ of possession. My name, my address. My 12 acres outside Madoc, Hastings County, Ontario. The property my late wife and I had bought 26 years ago with the specific understanding that it would belong to us until we were finished with it. I didn't say anything yet. I looked past the constable's shoulder, across my gravel lane to the road, where a black F-150 was parked with 2 wheels on the shoulder and 2 on my neighbor's dead lawn. The window was down. My son-in-law leaned out with his phone raised, already recording. He was grinning with every part of his face. "Let's go, old-timer," he called across the yard. "I've got contractors waiting." I looked back at the document. I found the applicant name on the 3rd line. Hargrove Properties, Inc. I recognized it. Then I looked at Constable Merritt and asked him one quiet question. His grin, the one he'd been wearing as professional composure, slipped off his face completely. "Welcome to Chosen Vengeance. If what you just heard speaks to something you've lived through yourself, stay close." Before we go any further, I want to ask you something. If someone you loved and trusted turned out to have been working against you the whole time, would you confront them the moment you found out? Or would you go quiet, let them believe they'd won, and take your time building the trap? Tell me in the comments. I want to know. A note before we continue. Some details in what follows have been adjusted for the sake of telling this properly. Any resemblance to specific living individuals is coincidental. What I can tell you is that the truth at the center of it is real. My name is Cedric Dunmore. I am 67 years old. For 32 years, I worked as a civil engineer with Ontario Power Generation, conducting structural assessments on hydroelectric dam facilities along the Trent-Severn waterway. I retired at 62 with a pension, a partial hearing loss in my left ear from 3 decades of turbine rooms, and the deed to 12 acres outside Madoc, rocky Canadian shield land with a creek at the back, a proper woodlot, and a perennial garden my wife had planted the first summer we moved in. My wife passed 4 years ago, pancreatic cancer, diagnosed in February, gone by November of the same year. After she died, I lived alone on the property and discovered gradually that I preferred it that way. There was enough to do: the garden, the woodpile, the creek. I had taken up fly fishing badly and did not intend to get better. I had hockey on television in the evenings. I thought that was sufficient. Then my son-in-law had a plan. He had never been easy to fully trust. My daughter brought him to dinner 7 years ago. She was 30, he was 34. And from the first evening there was something in the way he handled a room that set off the same instinct I used to get standing on a damn catwalk when a gauge was reading wrong. Nothing obvious. Just a faint, persistent signal. He ran a construction company out of Belleville, or said he did. He had expensive business cards and a ready answer for everything. My daughter worked as a mortgage specialist at one of the major banks, and I always understood that her income was the actual foundation of their household, though nobody said so aloud. I loved my daughter. I want to be straightforward about that, because what came afterward made it difficult to remember. She had her mother's laugh and her mother's stubbornness, and she called every Sunday without fail. I had no idea she'd been watching the property records. It started the way these things seem to start. A crisis, at night, in the cold. It was early March. The snow was that gray, stubborn kind that won't leave. I was in bed by 10 and asleep by 10:15 when the phone woke me just past 11. My daughter, crying before I got the phone to my ear. They arrived 40 minutes later, both of them, her in her work clothes with mascara tracked down her face, him in a jacket thrown over a flannel shirt. I made tea. I sat across my kitchen table from a man performing devastation and a woman who was my only child, and I listened to the story they'd rehearsed. My son-in-law's version was this. A former business partner had filed a malicious lawsuit against his construction company, claiming breach of contract on 2 major projects. The lawsuit had triggered an injunction freezing all corporate accounts and their personal credit line. Their Belleville mortgage was in arrears. If he couldn't secure bridge financing by the end of the week, they would lose the house. The bank will extend it, he said, turning his mug in his hands, but they need to see a clean asset behind the application. Something outside the litigation. Something real. I told him I could write a personal check. I had savings. I'd been careful. He shook his head. A personal loan wouldn't address the structural issue, he said. What the bank's underwriters needed to see was a tangible asset registered against the portfolio. A property. Then my daughter put her hand over mine on the table. Dad, her voice went small. You know what Mom asked you. You know what you promised her. My wife, in her last weeks at the Peterborough Regional Palliative Unit, had held my hand and asked me to always be there for our daughter. Those were the words she used. Always be there. My daughter had been in the room. She knew exactly what weight that phrase carried for me, and she used it the way you use a lever, precisely, deliberately, with both hands. I told my son-in-law I wouldn't put the property up as collateral. It was the last place my wife had lived. It was not a financial instrument. He pulled back immediately, raising both hands. He wasn't asking for that, he said. He was suggesting a family trust arrangement, a standard estate planning tool used across the country. The property would be registered as a managed asset under his company's corporate portfolio. The bank would see the backing and approve the financing. In 6 to 8 weeks, once the injunction was lifted, the whole structure would be unwound. I would keep living here exactly as I always had. As an added benefit, he said, this type of arrangement was commonly used to shield property from probate and CRA exposure when passing assets to the next generation. He spoke smoothly about estate protection, about capital gains tax on inherited property, about the Income Tax Act. It was polished and it sounded correct because the general framework he was describing actually exists. Family trusts are legitimate instruments. I had reason to know that better than he realized. I told them to come back in the morning with the paperwork. They arrived with a paralegal from Belleville named Curtis, who wore a wrinkled suit and had the slightly frantic energy of someone who hadn't slept. He set a thick folder on my kitchen table and opened it. My son-in-law stood behind him and narrated each section as I worked through it. Trust, administration language, management rights transfer, indemnification clauses. The first several pages matched exactly what he described the night before. I should have read every page. I need to say that plainly. 32 years of reading engineering contracts, and I stopped at page 9 of 40 because my daughter's face was across the table, and I believed I was doing something that mattered. What I missed was on page 16, surrounded on both sides by standard corporate boilerplate. A transfer deed of land, 1 page. My signature on the signature line, my initials in the margin, and Curtis's certification stamp below. That 1 page did not transfer management rights to anyone. Under Ontario's land registration system, it transferred full legal ownership of my 12-acre property, the house, the woodlot, the creek, everything, to Hargrove Properties, Inc. I signed it and believed I was helping my daughter. That afternoon she called to say the bank had approved the loan. She sounded better than fine. She sounded the way people sound when they've gotten away with something. The first crack in their story appeared 11 weeks later, on a warm afternoon in late May, when a woman pulled into my lane in a Toyota Highlander and climbed out with a clipboard and a digital camera. She introduced herself as a commercial appraiser. She said she'd been retained to assess the property's development potential for a mixed-use retail project. I asked who had retained her. She checked her file. Hargrove Properties, she said. The name sat in my chest like cold water. I told her this was a private residential property. She showed me the site plan she'd been given. A drawing of my 12 acres with my house removed and replaced with a strip mall, a drive-through, and a surface parking lot large enough for 80 vehicles. My wife's perennial garden was under the parking lot. I thanked her calmly, walked back to the house, and sat at the kitchen table for a long time. I called my daughter from the yard. She answered from somewhere with background music and the sound of glassware. When I described the appraiser, she told me in a gently patronizing tone that I was misunderstanding routine bank procedure. Large acreage properties always required commercial assessment. She had to go. She said she'd call me Sunday. I hung up and sat with the silence. 32 years on dam structures. The training is absolute on one point. When a pressure reading is wrong, you don't interpret it charitably. You pull the data. You trace the fault back to its source. You do not want to be wrong about this, but you cannot afford the comfort of hoping you are. I drove to the land registry office the following morning and pulled the title history on my property through TerraNet, Ontario's electronic land registration system. The transfer deed of land was filed and registered. My signature was on it. Curtis's certification was on it. It had been processed 2 days after they sat at my kitchen table. On the face of the record, I no longer owned the property I was standing on. I drove home. I didn't call anyone. What my son-in-law did not know, what he had never bothered to check, was that the title history went back further than his filing. When my wife was diagnosed in February of 2021, I did what engineers do when a system is about to fail. I looked for the failure point and I engineered around it. We sat with an estate lawyer in Peterborough, a firm with no connection to anyone we knew in Belleville or Madoc, and we talked through what came next. My wife had one specific fear, not her own death. She had made her peace with that far faster than I had. She was afraid that I would be talked out of the property once she was gone. She knew our daughter. She loved her with her whole heart, and she knew exactly what she was. She made me promise to protect it. In the spring of 2021, we established an alter ego trust, a structure recognized under subsection 248(1) of the Canadian Income Tax Act, specifically designed for individuals 65 and older. The property was transferred into the trust. A corporate trustee in Peterborough was named as sole administrator. I retained the legal right to live on the property for the duration of my life, but I held no authority to sell it, mortgage it, or convey it. The legal owner was the trust. My signature on any document purporting to transfer the property was not merely invalid, it was legally void, a nullity. I cannot deed away what I do not own, and I had not owned the property for 3 years before my son-in-law sat down at my kitchen table and asked me to sign. He had built his entire scheme on a foundation that did not exist. I found a litigation lawyer in Toronto, a veteran of commercial fraud and asset recovery, with an office on Bay Street and a reputation for not settling. I drove in on a Thursday, laid out everything I knew, and gave her the TerraNet records and the appraiser's site plan. She listened without interrupting. Then she told me that using a fraudulently obtained transfer deed of land to secure a mortgage from a chartered bank constituted fraud under Section 380 of the Criminal Code of Canada, not a civil matter. A criminal one, with a maximum sentence of 14 years. She also confirmed that the deed was void, and that the mortgage my son-in-law had taken out. She'd already located the filing, was secured against an asset he could never lawfully hold. He borrowed money from RBC using a building he doesn't own, she said, leaning forward across her desk. The bank holds a lien against nothing. That's not a property dispute. That's fraud against a federally chartered institution. I asked how we should proceed. She said we needed to let it run a little further. Document the bank transaction, build the intent record, then let him file the eviction and walk his fraudulent writ directly in front of a peace officer. Once he served the OPP document, his criminal intent would be fully established, and the RCMP Commercial Crime Unit could proceed. Go home, she said. Let him believe he's won. The performance I gave over the following weeks was, I think, some of the best work of my life. I let my son-in-law find my keys in the refrigerator. I'd placed them there between the milk and a block of old cheddar, specifically because I knew he'd be the one to reach in for a beer. I watched from the hallway as he pulled them out, shook his head, and muttered something to my daughter. I missed 2 consecutive Sunday calls, then apologized both times by saying I couldn't work out the new phone. I mentioned chest tightness twice during their visits, and watched my daughter exchange a glance with my son-in-law that was not a worried glance. It was a timeline glance. They both bought it completely. Their guard dropped. They stopped tracking me carefully. They simply waited. 3 weeks before the constable came to my door, my daughter visited on the pretense of dropping off soup. She moved through the house with the proprietary ease of someone who believed it was already theirs. I made tea and spilled some. She cleaned it up with the tight efficiency of a woman performing patience. While she was in the bathroom, she excused herself, and I timed it. I opened her bag where she'd left it on the counter and placed a voice-activated recorder in the interior zip pocket. It was the size of a box of matches. I paid cash for it at an electronics shop in Peterborough. She kissed my cheek on her way out and said she'd call Sunday. 2 days later, through the speaker on my workshop bench, I heard what they said when they believed no one was listening. My daughter's voice was different in her own kitchen. The warmth was gone. She described my decline to my son-in-law the way you describe a problem being solved. He laughed at the part about the keys. Then she said, "Once they move him, we cancel the GP. Walk in only, let the Ramipril prescription lapse." His cardiologist said without the blood pressure medication, realistically 6 months, maybe 8. My son-in-law said, "That works." I sat in the dark for a long time after that recording ended. Whatever I had been holding on to, whatever thin strand of paternal feeling had survived every prior discovery, went quiet in that moment. Not violently, it simply ceased. The way a line goes flat when the machine has nothing left to read. I drove back to Toronto the next morning. My lawyer listened to the recording and said what we had was sufficient for the RCMP Commercial Crime Unit out of Kingston to proceed on a criminal conspiracy charge alongside the fraud. She made calls that afternoon. I signed a witness statement. We agreed on the timing. Then I drove home and continued being a confused old man for 3 more weeks. The morning Constable Merritt knocked on my door. I had already been awake for 2 hours. I'd made coffee, watched the frost form and lift on the back field, thought about the deadfall I needed to clear before the ground froze solid. I was not afraid. Engineers who have spent their careers preventing catastrophic structural failure do not walk onto a damn catwalk with fear. They walk on with instruments and a plan. When I took the writ of possession from the constable and looked at the applicant line, I already knew what I was going to do. I asked Constable Merritt whether, before serving the order, he had pulled the property's Terranet title history, and whether he was aware that the registered owner of this parcel had been a corporate trustee in Peterborough since 2021, making any subsequent transfer deed entirely void, and that the writ he was holding had been obtained through a fraudulent instrument that did not convey legal ownership to anyone. He stopped moving. The professional composure left his face in stages. Across the lane, my son-in-law's grin had gone uncertain at the edges. I reached into my jacket pocket, not the phone my son-in-law had installed tracking software on, the other one, and connected it to the Bluetooth speaker sitting among my wife's terracotta planters on the porch railing. I had charged it the night before. I pressed play and moved the volume to the top of the scale. My daughter's voice came out of the speaker and crossed the yard and the lane and the flat October fields in every direction. Once they move him, we cancel the GP. Walk in only. Let the Ramipril lapse. My son-in-law opened the truck door and stepped out. He was still holding his phone, but it was no longer raised. His cardiologist said without the blood pressure medication, 6 months, maybe 8. He took 1 step toward the lane. Constable Merritt said, in a voice that had nothing left of its earlier apology, "Sir, I need you to stay where you are." "That works." My son-in-law's hand was on the truck door. He did not let go of it. He didn't get back in. 2 unmarked vehicles came around the south bend of the road at speed and did not slow down. RCMP, the Commercial Crime Unit out of Kingston, who had been in contact with my lawyer for 3 weeks, and who had been waiting for this specific moment when the fraudulent writ would be placed in the hands of a peace officer and the criminal intent would be fully documented and irrefutable. They boxed the F-150 before my son-in-law could make a decision. He stood against the truck with his hands visible, because the alternative had closed off. My daughter was in the passenger seat. I hadn't seen her get in. She was on the lane within 2 minutes, and when she looked up at me on the porch, her face collapsed through everything at once. She started toward me. She called out. She used the word "Dad" several times in a way that went up at the end, searching for something. I came down off the porch. I walked across the frost-stiff grass and stood close enough that she would have to see my face without any room for misreading it. "You planned it before you came to my door that night in March," I said. "The lawsuit was never real. The frozen accounts were never real. You needed the property, and you built a crisis designed to get past the one defense I couldn't reason my way around: your mother. She said she was sorry. She said things had gotten out of hand. I looked at her steadily. The property has been held in an alter ego trust since April 2021. Your mother and I set it up together 4 months after her diagnosis. An alter ego trust means the legal owner is an independent corporate trustee, not me. I can live here for the rest of my life, but I cannot transfer what I don't own. The deed your husband registered is void. The mortgage he took out against it is fraud under Section 380 of the Criminal Code. The RCMP has the bank records, the Terranet history, your appraiser's file, and the recording of you planning to take me off my medication. She didn't say anything. There was nothing left to say. You used your mother's memory as a tool, I said. That's what I'll carry out of this. I turned and walked back to the porch. Behind me, I heard an RCMP officer begin reading my son-in-law his rights under the Charter, the right to retain and instruct counsel without delay, the right to be informed of the charge. The words were clear and formal and correct. My son-in-law nodded slowly, his head barely moving, the nod of someone who has stopped processing anything except the immediate sensation of the world having closed in completely. My daughter sat down on the gravel. I don't know why. I stopped watching. Inside, I put the kettle back on. I stood at the kitchen window while it came up to heat and looked out at the back field. The lane was full of vehicles and people, but the back field was quiet. Down near the creek, 2 Canada geese were moving along the bank in no particular hurry, the way they always did at this time of year, indifferent to everything happening to the north of them. My lawyer had explained the rest of it to me plainly the week before. The alter ego trust would be confirmed as the registered owner. The void deed would be struck from the Terranet record. The RBC mortgage, secured against a property that never legally belonged to my son-in-law's company, would be unwound as an unsecured fraud. The bank's own legal team would be pursuing him separately. The RCMP charges would proceed through the Ontario court system. The process would take time. It always did. But the outcome was not in question. The kettle clicked off. I poured the water over the grounds and let it steep. My wife had worried, in her last weeks, that I would be too trusting after she was gone. She knew me well enough to know that grief could soften a person's edges. She made me promise to protect this place, not because she doubted me, but because she loved me, and she was afraid for me, and she wanted the promise to stand between me and whatever came next. She was right to be afraid, and she was right to ask. I finished my coffee. I rinsed the mug and set it on the rack. I got my jacket from the hook by the back door, because there was a good hour of light left, and the deadfall down by the creek wasn't going to clear itself, and the ground would be frozen solid within the week. I walked out through the back and across the field, boots on frost, the air sharp and clean and cold, the geese moving away from me along the bank without any alarm, and the property quiet in every direction, as it had been the morning before this one, and as it would be the morning after.